Hello there, Crista Hermance here, estate planning mom. So I am coming to you live as we are going to talk about estate planning questions and answers. So these are questions that you may have pertaining to wills, trust, probate court, trust administration. Maybe you had somebody that passed away and you're not really sure what those next steps are to help them. And so if you are joining me live, then I want to hear your questions. So please put any of those estate planning questions in the chat as I answer some questions that people have submitted to us over the course of the last few days. And then I did want to start on one specific topic, though, before I get into the questions. And that, hello, thank you for joining. I want to talk about estate planning for aging parents. And this actually came up in a conversation that I had yesterday with somebody who was talking about the sandwich generation. And so, if you know what the sandwich generation is, you know that or if you don't know what it is, I'm sorry, when you have an adult that has younger children, so let's say minor children under the age of 18, and also have parents that are aging that now they are kind of in this sandwich phase, right? And what is happening in this sandwich generation is the adult children they have their kids to take care of and are getting into situations where they are now taking care of their parents. And then for some, like I was in this situation that was helping with grandparents as well. And so it kind of puts us in a unique position, especially when it comes to estate planning, to make sure that specific plans are in place, whether it be a power of attorney, advanced healthcare directive, a will, a trust, just things that if something happened, if somebody got sick, those plans would be in place to make sure that you would be able to make decisions. So it's really important when planning for aging parents, right, in this sandwich generation, that you're looking at, what do the parents have? Like, what are the assets? What are the, if something were to happen to them and they were to get sick, are you going to have access to bank accounts? If they were to pass away, are you going to have to go through probate court? Is that something that you're going to be okay going through? Or would you rather avoid it? Would your parents rather avoid their estate having to go through probate and having a trust in place? So a lot of times, what I have found over the years is this is a really hard conversation to have with aging parents. A lot of times they are, at least for some older people that I've seen, they're very secretive about their financial situation. They don't really want to share that information with their kids. And so they just won't talk to them about it. But it's an important conversation to have, to just help give them the information about what is out there and available to be able to do from a planning perspective, to make sure that they're going to pay less money in fees, right? Money that's going to the courts and things that they generally don't want the money going to. And it's going to keep more money in the estate to be able to be either, spent on the family or given to their heirs. So really important conversations to have. I know that it's hard to do, but it's so important because then it allows you also just to know what their wishes are. Okay. So I see some questions coming in. If you're just joining me, please put any estate planning questions you have. So wills, trust, power of attorney, advanced healthcare directive, nominating guardians from your minor children. Please put those comments in the chat and I will get to them. So I see a few comments here. Okay, so what's the number one thing a single, financially stable 30-year-old should do to plan for future kids? Let's see. So let's stick with estate planning as the topic, right? So single, 30-year-old, financially stable plan for future kids. Well, creating a trust now is very important, I think, especially if you're financially stable, because that's just going to kind of help set that that base for you going forward. And whether you are going to get married and then have kids or stay single and have children, having that that trust with your assets in it. And you don't have to have kids now to have a trust. You can have anybody listed as the beneficiaries, have agents, I think is really important. But then it's just when you have children, you can add the kids to the trust. I think what it also does is if you're financially stable, it might mean maybe you have some separate property. And so this is going to allow you to now have a trust with your separate property in it so that when you get married, you already have a separate property trust, right? And so now when you get married, if you don't want to commingle all of the assets, your trust is already set up with those assets that they can be specific for your children if something were to happen to you. It's really just depending on what your goal is. But having a trust now will just allow you to just add the kids to it once you have that. I think just anybody over the age of 18 having a power of attorney document and a HIPAA authorization, an advanced healthcare directive, some people might know it as a living will, all very important documents, because if you were to get hurt, injured, sick, if something were to happen to you and you didn't have capacity, these are the agents that you have identified to be able to step in and be able to assist. One thing that people will, kind of argue with me on this about is, well, why can't, if I don't have any kids, why can't I just list beneficiaries on all my stuff? And you absolutely can. The problem that I see with this form of estate planning is just listing beneficiaries is beneficiary designations only come into play when somebody actually dies. And so as a 30-year-old, if you were to get sick, nobody is going to have access to your accounts, right? Because you don't have that trust or you don't have that power of attorney. And having them as a beneficiary on your accounts doesn't give them any access to it. And so by having a trust, you can say, if I were to get sick, here's somebody that can step in to manage my finances, help support me financially from my money without them having to use their own money. Okay. Okay. I see some more questions coming in. Let's see. What's your advice estate planning for child-free couples with immediate and extended family located internationally? Great question. So the biggest thing is having planning documents in place for incapacity. So advanced healthcare directive, power of attorney, HIPAA authorization. If somebody is out of country, depending on how far out of country, and if there's U.S. citizenship, those are all things to kind of take into consideration. But by having those documents, is if something happened to you, your spouse definitely being maybe as the primary agent, and then having, I wouldn't necessarily put international people as agents, but maybe on HIPAA, right? So that if you were in an accident, they would be able to call the hospital and find out what's going on if you were on the HIPAA or if they were on the HIPAA release, or once they were able to get there. Any friends that you have locally within the United States are people that you can use, but they need to be people that you trust. So that if something were to happen to both you and your spouse, then they could step in and be able to assist with a mortgage, nursing care, hospital costs, anything from that financial perspective, you can have somebody step into. Obviously, having a trust is a really great way to make sure that your assets would avoid having to go through probate. And you can have an agent that would need to be a U.S. citizen. And for any of these roles, there are professional fiduciaries that can step into this role. So if you didn't have somebody that you could trust here, you could have a professional that would come into play when needed, and then they would get just paid as part of the trust administration or the fees for acting in that fiduciary capacity. And what that would allow you to do is to be able to leave gifts to people that weren't necessarily in the United States. And maybe you had people that were outside of the US that you wanted to be able to give gifts to. Okay. Okay. Great question. Okay. If you're just joining me, thank you so much. My name is Crista Hermance. I'm an estate planning attorney. Our firm is Hermance Law. You might know me as Estate Planning Mom. We are licensed to practice law in the state of California. So anything I talk about, it's great information, but if you are in another state, I'm sorry, but we cannot assist you. However, we do work with attorneys all over the country. So please send me a message if you need an attorney in another state, and I'm happy to give you the names of some of the attorneys that we work with. Okay. Okay. And if you have questions, estate planning, so wills, trust, probate, trust administration, advanced healthcare directive, power of attorney, please put your question in the chat, and I'm getting to those now. So I'm going to go to the next one. Okay. If my parents' estate is in probate, what things would you recommend me to do and not do? Okay, I'm going to have to make some assumptions on this one because I probably need more facts to know what role or what capacity are you acting in. So for this one, I'm going to assume that you are in charge of your parents' estate. And now the assets are essentially frozen at this point because they're going through the probate process. So things that you should be doing are gathering all of the assets together, getting statements for everything from the date of passing until up to now, right? What are all those statements say? Finding bills, right? You have a duty to act responsibly, not spend parents' estate money. It needs to be in a separate estate account because that is going to have to go through the final phase in probate where it's going to get approved by the court. They're going to want to see an accounting. Other things for you to do, don't pay yourself back out of the probate estate. Don't pay anybody else back yet. You need court approval for that. And, if somebody's begging you for money for a distribution or family members, unfortunately, it's not in your hands to be able to do those distributions, right? There has to be that court order that says, here's how the distributions can go. I've seen people get in trouble for this, right? They're distributing money when they don't have the authority to do that, or paying bills, not necessarily paying bills, but reimbursing people for money that they've paid. You got to get court approval for that. If you own a property, I think I saw some real estate agents on here, work with a real estate professional that knows how to do probate court. There's a lot of very specifics when it comes to probate. And so I work with a lot of great ones if you need any recommendations. Because you want somebody that knows what they're doing. But houses, and I think a lot of people have this misconception, is that the probate actually has to happen for a house to be sold as part of the probate. And that is not necessarily true. Depending on how the petition is and what type of authority you have, at least in California, you can, once you get the letter saying you are in charge of the estate, then you have the ability to sell the property as part of the probate estate. And those proceeds are going to go into that probate estate account. So you can't touch it until the end of the court, but it can be sold as part of that process. Sometimes people wait to sell a house once probate is completed. And I will tell you that there is going to be generally less liability for selling it through the probate proceeding because now you're doing it as an agent. Right? You're doing it as the person that's in charge of the estate, and it's through that probate proceeding. Whereas if you do it after the probate estate and now the house has just been transferred to you and maybe your siblings and you're selling it, well, at this point, you've now taken ownership and it's now yours. You have higher liability that if there's something wrong, right? So sell it as part of the probate proceeding. Okay, I hope that helped on the things you recommend. And this is something that we do for clients. So we do probate court throughout California. We have cases all over the state. And it's, if somebody passes away, they own assets in their own name, and those assets have to go through probate court to be able to be distributed to their heirs or beneficiaries. These are things that we can assist with. We actually even help attorneys in other states where somebody owned property in California, and we are just doing that probate for just that specific property. That's one thing that a lot of people don't consider is if you own property in various states, generally it would be a probate in every state that you own property in. Whereas if you had a trust, like in California, you could say, well, I'm in California, I have this trust, I have my primary residence, I'm going to put that into the name of my trust. But then I also own a property in Nevada or Arizona. So I'm going to put those properties into my California trust as well. So if something happened to me, my agent, executor, successor, trustee would be able to then go in and administer my trust according to my wishes without having to go through probate court in all of those states. Okay. I see some more questions. So if you're just joining me, please feel free to put your estate planning questions in the chat. I'm going to go to the next question here. How do you suggest people handle institutions that refuse to honor POAs that are older than 90 days? Wow, 90 days. Seems like an illegal and very common practice for institutions to push back on any POA right now. It is unfortunate. And 90 days, that is a very short time frame. But in the 13 years that I've been doing this, it's always been the same with institutions. They unfortunately, they make it really hard sometimes. There's some banks that are easier to work with than others. Some banks that have their own power of attorney that they want you to sign. And I mean, to me, it's like, well, I had this estate plan, and if there was some problem, now I have a problem and I need to use the POA. Now you're telling me I need to use your POA. And so I feel like that's stuff that they should have provided, like when we open the accounts, like, here's a power of attorney. If you ever need somebody to access it, you should give this free, because I completely understand the frustration on this one. And unfortunately, banks are just so big to deal with that they have so much push that we don't necessarily have. And I have attorney friends all over the state that have the same issues. And so, I mean, it's unfortunate, and I'm sorry. Sometimes going to another bank, maybe another branch, and seeing if you can get it working with somebody else. I find with banks, depending on the bank, because some banks I found are easier to work with than others, is maybe you get somebody that isn't well versed in what what the procedure is. Like, I've had bank tellers tell clients, like, oh, you should just put this money in your account. I was like, well, I don't know why they're telling you that. Please don't do that, because that's an estate money. We need to keep it separate. Or other people at the bank tell clients, like, oh, you need a court order for this. And it's not true. We just need to file an affidavit, and we can do that much easier than having to go through court. And so I think try and go to a different bank. Try and talk to somebody else and see if that you can get somebody else to help you with it. I think that's, at some point, that's all we can do, is, unless the documents, probably if they have their own power of attorney document, if it can be signed now. So I'm sorry. Okay. If you are looking for a free emergency sheet, this is a lot of stuff dealing with children, information, medical providers, emergency contacts, kind of like the babysitter's guide that you would leave for a babysitter, or something to keep on the fridge. If you have kids that stay home alone, please put parents in the comments, or send me a message, and we'll get that free printable sent over to you. And again, if you have questions, we have free consultations. If you want to get your estate plan together, you're not really sure where to get started, or maybe you need some help with some other situations where somebody's passed away, please send us a message, and we can get that free consultation link scheduled for you. Okay, I see another comment here. So again, if you have any comments, please put those in the chat. This comment, it seems that living trust can trigger some tax implications if you move overseas for work. What could be the options in that case? I am not a tax advisor, so I'm sorry, I can't refer to tax questions. You're going to need to talk to a tax professional about that, especially if it's overseas for work. But I will say, from a living trust perspective, living trusts are just property that's in your name that's associated with your Social Security number. And so I'm not sure what tax implications. And again, this is where you need to work with a tax professional on what those would be. Because again, it's still your assets. You can, with a living trust, you can sell those assets, do anything you want with them at any point throughout your lifetime. Okay. Okay. So next question that came in. Can you please explain what type of trust can protect residents from probate? Yes. So a revocable living trust, or a living trust, or a revocable trust, or just a trust, they're all the same meaning. They are just different words that sometimes are used depending on who's doing them. They all mean the same thing. A revocable living trust, when you have a revocable living trust that you create, you are taking your home and you are creating a deed. We use a grant deed, and that grant deed is going to say from you as the owner of the home to you as the trustee of your trust. Okay, thereby changing title to your trust. So then if something happened to you, now your successor trustee or executor can step in according to the terms of your trust, and it wouldn't have to go through probate because it's not in your individual name. It's now in the name of your trust. Okay. Okay. So I have another comment here. I think it's about the POA one. Just tricky to have parents who don't want kids to have current control. Okay, so that helps me a little bit with maybe some ideas for you. So power of attorneys, and this is where if the parents have capacity in California specifically, and I know other states have it. I know specifically Florida does not. There is a term called a springing power of attorney. And so what that does is that allows you to say that the power only springs into effect upon incapacity. So if the adult parents or elderly parents are in good health now and they don't want their kids to have control, totally understand that. This springing power of attorney could be something that would be helpful. The other part of that, now that I have a little bit more information, is having a trust. You don't even need that POA for the bank, that bank specifically. You still need a POA, but not for that bank. And then you take that account from that bank and you transfer it into the name of the trust. And then that way, while the parents are healthy and they have capacity, they have full control over their trust, over their accounts. And it's only if they were to get sick or to pass away, then instead of using a POA, that power of attorney, to be able to access the account, it's already in the name of the trust. So you just then use the power as the executor or the successor trustee to be able to go to the bank and be able to access the money and do what needs to be done for the trust administration. So hopefully that helps a little bit more, given there's more facts on the power of attorney. But having it in the name of the trust should prevent needing the power of attorney. And then it's not effective now. It's only effective if something happens. So something to look into. Absolutely. Okay. Okay. I see another question that just came in. At what net worth do you suggest someone needs to hire someone like you as opposed to using a pre-made template online resource? So we have no set, you have to have this net worth to be able to move forward, right? Or I had a client, it was very early in my estate planning career, and it was so puzzling to me. She said, we went to work with this other law firm and they wouldn't work with us because we didn't have enough in assets. And that just broke my heart because, they were a young family, they had 2 kids and they owned a home, they had investment accounts, they absolutely needed an estate plan in place and this firm wouldn't help them. Which I just thought was really, it was just, it was very unkind. So I don't think that there's a net worth. I think it's what are you trying to protect, right? So if there's minor children, I generally will recommend having a trust, especially in California, because usually there's maybe a life insurance policy and we want to make sure that, if something happens and there's minor kids, that life insurance policy can go into the trust rather than going to the kids directly, because minor children can't actually inherit life insurance policies or retirement accounts until they turn 18. Right. And then it goes into a court blocked account that they would get access at that point. And so having a trust just provides so much more control. Using DIY plans and things online, I've seen some that get the job done, right? They're maybe not as robust. It also, I think, goes back to how tech savvy is the person or the couple that's doing them. I found some clients that have started the DIY method. They were online, they were doing it. And 2 things. One, because they weren't working with a professional like us to be able to kind of keep them on track with a timeline of when it needed to get done, it just never got done, right? It was something else. that it was just like something on their to-do list, but they would get to and they got to it and they never did. So then they came to us, they're like, look, we need you to hold us accountable. We're going to get this done. If you're setting these appointments, and we have to do this work. So that's one thing. The other one, the client I'm thinking of specifically, as they were going through the questions, they were getting confused by who goes in what role. And it was just too overwhelming for them to not have that counsel that working with an estate planning attorney is, to be able to talk through, like, okay, what are these people need to do? What are the roles that they're going to have? And just things that in our experience and things that we see from when somebody passes away, we might counsel on saying, what, let's rethink this, or, what other options do we have, and trying to come up with a plan that best fits those families' needs. I will say on the DIY side too, is I find that people have a false sense of security with DIY plans because they think they do them online and that they're just done, right? And so the issues that I've seen with these is, one, they don't sign the documents correctly, which means they're invalid. One specifically, client created a trust online, never put any of his assets into the trust, but he never signed it. And so when his son came to me after he passed away, we had to take his $3 million estate through probate because he didn't sign his trust, right? And it ended up costing them, I think, over $40,000, which was unfortunate because, son was like, oh, dad got his trust. He said he got it done, but he just didn't sign it. So that's one thing, is I've seen them not sign correctly. The same thing with wills. People get this idea like, oh, I just need a will, right? Like I don't have any assets. I don't need anything big. I just need a will. But a will doesn't really provide that much protection, right? All a will is doing is it's saying is, when you pass away, here's how you want your assets distributed. Here's who you want to be guardians of your minor children. And so a will doesn't do anything, like that power of attorney document I was just talking about. It doesn't do anything to help when the parents get sick, right? It doesn't do anything to help if you need to sell a parent's home or do anything while they're sick. It only comes into play when somebody dies. And so the problem with the DIY will is that, one, it gives people this sense like, oh, this is all I need, right? I don't need anything else, which is not true, right? There's a ton of other documents that make up a comprehensive estate plan. And then two, not being signed properly. Like I've seen people, well, they'll complete the will online. I'll get a copy of it, and the person's passed and it's been notarized. And at least in California, that's not sufficient. In California, we need 2 witnesses that are over the age of 18. The notary can act as one witness, but it's missing that second witness. Okay. So that was a lot, but I have a lot to say on DIY plans. It's just, I think sometimes it does work for some families. It's just making sure that it's done correctly. That might be something that we should look into doing, is helping people that have done DIY plans review them and make sure that they are actually good. So maybe I'll break that one down to help families with. Okay. Okay, so I see some comments here. I think this is relating to the power of attorney thing we were talking about with the bank. Just tricky to have parents who don't want to have kids have control. Yes, we already talked about that. And then just to be sure, they have the bar low for having them deemed incapacitated. Well, there's different ways to be deemed incapacitated. A couple that I've done are, they're like, the standard is generally 2 physicians is kind of an incapacitated one. You could do 1 physician, like a family doctor that's known them for a while. Another option is doing what's called a panel. And it's basically, and you could say in this panel of people, and identify who these people are. And I have a client I'm doing this for right now, actually. You can say, I want this panel to be able to decide if I'm incapacitated. And you could say it has to be a majority or it has to be unanimous, right? And so really creating these plans that allow you to have those specific requirements or the needs of what you want in your plan. Okay, last question. I see, and if you're watching this in a replay, please put your questions in the chat, or send me a message, and I will get to it when I do a live tomorrow. So join me back here tomorrow to go through some more estate planning questions and answers. So I'm going to finish this one with things I would never recommend as an estate planning attorney in California. Oh, let's see. What would I not recommend? Okay. First one, adding your adult child onto title for your property, right? Do not do that as an estate planning method. And the reasons for it, there's 4 that I can think of off the top of my head. One is there could be some type of reassessment that's done on the property. And it may not be valid a reassessment, but the assessor's office does the reassessment. You have to pay the money, and then and you then have to fight it. But you have to pay the money while you fight it and potentially get a refund if they made a mistake. But there's that chance, right? The second thing is, what if you get in a fight with your kid and you add them to title of your property? Well, now they are co-owner of your property. And so if you want to refinance your house, if you want to get a second mortgage on your property, if you want to sell your house, they have to sign off on it. And if they don't agree with what you're doing, which I have seen, or you're not talking because something happened, then they're not going to sign it, right? And they have that ability as a co-owner now. What if they have, number 3, what if they have creditors, right? What if there was a car accident and their policy limits didn't cover the damage to the other party? Now that party that sued them can now come after that house because it's in their name, right? And the last one, which is a really big one, is when you add your child to title while you are alive, the house would get what's called step up in basis in the property gain taxes. I'm saying I'm wrong. Sorry. But let me explain it and then I'll remember how to say what the correct terminology is. So let's say that your parents bought a property in 1980 for $100,000. Okay. Now the property is worth $1 million. Okay. And so if your parents added you to title, to just put you on title so they could avoid having to go through probate, and you would just get the house when they died, you now being on property would be responsible for the capital gain taxes. That was the word. I told you I remember it. From $100,000 to $1 million, right? Whereas if you just inherited it from your parents, like through a trust, then at their passing, you would get that step up in basis. So now the property would be worth $1 million and you wouldn't have to pay those capital gains taxes, right? And that could be a lot of money. So those are the things that I would never recommend as an estate planning attorney that I think are really important. And I have lots more, but I do need to wrap it up for today. So thank you so much for joining me. I hope this was valuable for you. If it was, put something in the chat. Let me know you're listening, and I will be back here tomorrow. So I will see you then. Thank you.